What's up, everybody? Welcome back in to another episode of The Lawyer You Know. And I'm excited to talk to you about this one because we knew it was coming. The House defendants have moved to remove this case to federal court. It's a 1983 action, feels like a federal case, but there are some arguments against removing it to federal court that a judge is going to have the discretion to make this decision. We're also going to talk about some of the differences in federal court and state court today and whether or not we think it will be removed. But lastly, there's also more Proctor problems because they've subpoenaed him multiple times and he seemingly is having lawyer problems. We're going to read through that motion to compel his turning over discovery in this case and if his lawyer issue could potentially affect the removal action. So a lot to talk about today. Can't wait to do it with you guys to answer your questions. Let's get to it. I love the holidays. Like, is there any time to be in a better mood than right now? We're about to just go into the thick of it. So much time with family and friends to enjoy and look back on the year. So much to be thankful for, even though a lot of us I know have had tough times and tough things happen. But it's just an amazing time of year. I'm always just in a good mood and the weather starts to change. And that's pretty much all I need here in Florida to change my mood. Charlie, thank you so much for gifting 10 Lawyer You Know memberships. It's the season of giving. Thank you guys so much. Hit that like button if you're feeling like giving some more. The first document we are going to look at together is this removal action. What you'll notice is at the top of the page, it says the United States District Court for the District of Massachusetts. So the person deciding this removal decision, whether or not the Karen Reed versus the cops and the House defendants, whether or not they will be removed to federal court is going to be made by a federal judge. The federal judge needs to determine whether or not this is a case that should be in federal court. And if it is, he will take it there. He will take it there. By the way, I heard some people that had an issue with me calling them the House defendants. That's what they're named in multiple motions. So it is what it is. And it's a lot less of a mouthful than name everybody. So cops and House defendants is probably what I'm going to be calling them, even though Proctor's not a cop, which may bother some people, but it is what it is. And that's the quickest way to do it. So their notice of removal, and let's talk about the grounds. Okay. Grounds, as Daryl Brooks would say. On or about November 17th, plaintiff Karen Reed filed the above captioned action in the Superior Court. The complaint purports to assert 7 causes of action, including 1983 actions, and they go through all the actions. There are state and federal actions in here. A true and correct copy of the complaint, civil action cover sheet, civil tracking order, acceptance of service from Brian Tully, acceptance of servants from Albert, McCabe, Higgins is attached here too. Those exhibits are attached. We're not going to read through all of them. By way of background, the Superior Court action arises from plaintiff's ongoing and malicious attempt to evade responsibility for the death of John O'Keefe by smearing and defaming witnesses who participated in the prosecution of her. This case is a vengeful abuse of judicial process, and removing defendants will make arguments in that regard at the appropriate time, which is not now, if I might add. It is not now. So for them to continue to drone on about the fact that this is a malicious prosecution and they're wasting the court's time, et cetera, not what you need to argue in a removal process. And to me, usually you don't bring that if you have a strong argument. And I think they have some really strong arguments here, the cops and the House defendants. So I don't think you need to throw that in because all you're doing is risking pissing the judge off and the judge being like, you know what, stay in state court. I don't want to deal with you guys because this is purely a judicial discretion decision. And from my perspective, it's all going to be about what this one judge that looks at the case sees. Removal. Counsel for removing defendants accepted service of process on removing defendants' behalf on November 25th. Okay. And this is going to be important. Because in order to do this removal, it's got to be done within 30 days of service, but these defendants have to be served. All the defendants have to agree. And if the defendants don't agree, then that's obviously going to create an issue for the judge. Usually it doesn't get removed. So that process and where we're at, there are some holes in some people's stories. Therefore, removing defendants are timely filing this notice of removal within 30-day period from the date of the service set forth in this rule. 30-day removal period run from service of summons and complaint. So counsel for removing defendants accepted service. That's what it says here in paragraph 3. right? All named defendants who have been served, which means like maybe not all of them have been served, but up here it sure sounds like they've all been served and that counsel has accepted service. I'm not sure if that's true or not. It's kind of hard to tell based on some of the other parts of this motion. Defendant Brian Tully's acceptance of service was docketed on the Superior Court on November 24th. Counsel for Tully has confirmed that he assents to this removal. While no acceptance of service has yet been filed with respect to Buchanan's counsel has informed undersigned counsel that he consents to removal. Is that in writing somewhere? Are we taking your word for it? How do we know that? There's nothing on the docket. Who is his lawyer? Like, I take issue with that, and I'm not a federal judge. Some federal judges can really be sticklers and be like, I'm going to need more information. Upon information and belief, why would it be upon information and belief? To me, it just feels like it should be counsel for Proctor also assents because he told us this. Upon information and belief is usually when an opposing party says something they believe you're going to say or do, or information they have that's telling them it's going to happen, but it doesn't mean they like, no, usually. Upon information and belief is like, I believe this is what's going to happen or this is how it's going to come out. Usually. Defendant Michael Proctor has not yet been served, but his counsel, okay, again, making a statement, his counsel has advised undersigned counsel that defendant Proctor consents to the removal as well. So that to me tells me a couple of these defendants have actually not been served. Will that be an issue? They can cure that problem for the majority of these things, but maybe it'll cause some kind of delay. And then number two, it clearly says Proctor has a lawyer, right? And his lawyer on his behalf is talking to these other attorneys representing the McCabe's, Alberts, Higgins, Tully, Buchanan. That's what it says to me. Now, not the smartest guy in the room. So I get it if I'm just wrong. You guys can let me know if you disagree with that. A civil action removed pursuant to section 144A requires consent of all defendants who have been served. All defendants who have been served. Venue is proper in this court pursuant to 28 U.S.C. 1441A and 1446A because the United States District Court of the Middle District of Massachusetts is the federal district in which the Superior Court is located and where the state court action was originally filed. As required by 28 U.S.C. 1446D, removing defendants will properly serve written notice of the filing of this notice of removal and the removal of the state court action on counsel plaintiff as evidenced by the attached certificate of service and will promptly file the same with the clerk of the Superior Court. And we're going to look at some of these federal rules here together as well. Pursuant to 28 U.S.C. 1446A and this rule in Massachusetts, within 28 days of the filing of the notice of removal, removing defendants shall file certified copies of all records and proceedings in the Superior Court, as well as a certified copy of the docket and all docket entries. The removal of this action terminates all potential proceedings in the Superior Court. So once they file this removal action, and it is a decision for the federal court to decide, okay? Then it basically stays the state proceeding. It stays the state case. So the case that Karen Reed filed, that is something that we're going to put on timeout right now. We're going to hold right now. Nothing is going to happen. There's not going to be any discovery. This is important for a few reasons. Reason number one is we have heard discussions about potentially consolidating this with the O'Keefe v. Reed et al. Wrongful death case. We've also heard Diller, the attorney for the O'Keefes, say he wants to consolidate discovery. And one of the issues with that is delay. And we know that the O'Keefe v. Reed et al. Case is past the motion to dismiss phase. What that means is both sides have had their opportunities to file their complaint, their motions to dismiss, their responses, their answer. That's kind of the first phase of the case. Then we get in discovery once we know the case and the complaint is going to stick here for the long haul. There's a lot of other steps coming, and we're going to learn so much about civil procedure because of this case. I'm excited. I hope you guys are too. Well, this case has not even really gotten to that level yet because they want to remove it to federal court before they file their motions to dismiss. And they've also said that we're going to file our motions to dismiss if and when we lose that, because usually you do lose motions to dismiss, we are going to file counterclaims, meaning they're going to sue Karen Reed and maybe Turtle Boy. And then, Judge, once we file those counterclaims, we think Reed and Turtle Boy are going to file their motions to dismiss. So that's where this delay comes. That's why we shouldn't consolidate, yet we're still asking to consolidate for discovery. Those same delays are going to be there. So you can't use the delay as a reason you think it shouldn't be consolidated, but still say you want to consolidate and those delays don't matter to consolidate for discovery. And sure, cases can be consolidated for just discovery, but if I'm arguing I want them consolidated completely, it's a pretty good argument. Okay, I will pause here because I keep getting this in here. Peter, some people are donating to the McAlbert Fund and using your name. So to make this I thought this was obvious, but we'll make it as clear as possible. I have never donated 1 cent to any public fund for any legal fees for any case I've ever covered, nor will I. I don't want to be biased to one side or the other. Which doesn't mean I'm going to think one side's right and one side's wrong. That's going to happen. I'm going to think there's a winner and a loser. I'm going to call a winner and a loser, but I'm not going to donate to either side ever. And I've never given 1 cent to Karen Reed's fund, and I've never given 1 cent to this House defendant fund. Period. End of story. Should be simple, should be obvious. That's not something I'm interested in doing. Not something I ever will do. I feel like I have my role and place in this, and I'm comfortable in that, and I like it, and I hope you guys do too. And that's to explain and talk about the law and dig in and help us learn about our judicial system, point out when things are problematic, and try to figure out ways we can make it better together as a society. Susan, thank you so much for gifting 5 Lawyer You Know memberships. Okay. Where was I? All right. Federal jurisdiction exists under 28 USC 1331. This is a civil action over which the court has original jurisdiction under 28 USC 1331 and is one that may be removed to this court under 28 USC 1441A because, as set forth fully below, plaintiff's federal civil rights claims against removing defendants, namely count 3, conspiracy to deprive Ms. Reed of her Fourth Amendment rights against Proctor Buchanan et al., is exclusively and expressly based on the federal statute 42 USC 1983, aka a 1983 action, and therefore raises substantial federal issues central to establishing plaintiff's claims for relief. In particular, plaintiff alleges in count 3 of the complaint that the removing defendants violated her federal civil rights by purportedly acting in concert to deprive her of her Fourth Amendment rights under the United States Constitution. Where a complaint invokes 42 USC 1983, federal question jurisdiction exists. And then they cite some cases, and they're right. They're absolutely right. We knew this was coming. But we also said this case is very different, and the judge is going to have to look at this case differently. And I'm going to talk about what some of those differences are and what I expect Karen Reed's team to argue, at least in part, if they don't want this removed, which if I were them, I probably wouldn't want it removed. We'll talk about why in a little bit. In addition, this court has jurisdiction over the remaining counts of the complaint by way of supplemental jurisdiction under 28 USC 1367A, which provides a relevant part in any civil action of which the district courts have original jurisdiction. The district court shall have supplemental jurisdiction over all other claims that are so related to the claims in the action within such original jurisdiction that they form part of the same case or controversy. So what this means, this paragraph is just basically saying, Judge, we agree with and recognize the fact that all of the claims, all of the causes of actions, all of the counts in Karen Reed's complaint are not federal questions. But under 28 USC 1367A, you guys, the federal court, can group all of those cases that are part of the same case and controversy, group them all together, and you can handle the state and the federal claims. I've had plenty of cases I've litigated in federal court that also have state claims with them. It's not that unusual. It's not going to be a reason the court's like, oh, no, we can't possibly handle these state causes of action. Indeed, the First Circuit has explained state and federal claims are part of the same case and controversy for purposes of Section 1367A if they derive from a common nucleus of operative fact or are such that would ordinarily be expected to be tried in one judicial proceeding. Some of this language is what Karen Reed's going to argue to also group in the O'Keefe's because, and I might even say, Judge, they said violating her Fourth Amendment rights, conspiracy to kill John O'Keefe, to cover it up, et cetera, et cetera. They said all of those facts should come together. All of those facts are exactly what's in the O'Keefe complaint too. And just wait until these House defendants and cops file defamation claims. Now it's even more one case and controversy grouped up with the O'Keefe trial. And that might be a very important argument here against removal for Karen Reed's team. Accordingly, this court may exercise supplemental jurisdiction over the remaining 4 state law and common law claims, counts 4 through 7 in the complaint. Wherefore, these defendants request that the state court action be removed to the United States Court for the District of Massachusetts and that the court enter such an order as may be necessary to accomplish the requested removal. let's take a second now, hop over to some of these federal statutes just so everybody can be on the same page and understanding what we're talking about here. So this is, let me move myself. Nope, that was the opposite of what I want to do. All right, 28 U.S.C. 1441, removal of civil actions. They cited it multiple times. Except as otherwise expressly provided by act of Congress, any civil action brought in a state court of which the District Court of the United States have original jurisdiction may, this is what I want to highlight, may be removed by the defendant or defendants to the District Court of the United States for the district and division embracing the place where such action is pending. Okay? We're going to, pop over to 1331 next. All right, and this is how we get it to federal court. Federal question jurisdiction. The district courts shall have original jurisdiction. That means if you want the case in federal court as a judge, you are allowed to. You have that power of all civil actions arising under the constitutional laws or treaties of the United States. So there's no doubt about it. This is a scenario where they can remove it to federal court. Chris K said, happy Thanksgiving, Peter, to you, your family, and the whole chat. I couldn't agree more. Happy Thanksgiving to all of you guys. Love you so much. I'm pumped. We got to hang out this week a little bit. I didn't know if I was going to do a live today. And then here we go. More stuff happening in Karen Reed's civil case, which allows us to hang out, which is a great gift to me. Okay, next we're going to go to 46. Thank you, Lisa, for gifting 5 Lawyer memberships. Now we're going to go to 1446, which they cited a couple different paragraphs. I'm going to pull back up their motion here. I'm going to scroll up and see they list 1446. I thought they did A, but B2A. So let's start with that. So B, requirements generally. 2A, when a civil action is removed solely under section 1441, all defendants who have been properly joined and served must join in or consent to the removal of the action. That's going to be something that feels like a gray area, feels a little murky right now. We're going to have to see, and we're going to hold some of that discussion for when we look at the next Proctor document. Was there any other sections? Yeah, 1446A. A defendant or defendants desiring to remove any civil action from a state court shall file with the District Court of the United States for the district and division within which such action is pending notice of removal, signed pursuant to Rule 11 of the Federal Rules of Civil Procedure and containing a short and plain statement of the grounds of removal, together with a copy of all processes, pleadings, and orders served upon such defendant or defendants in such action. Seems like they did all of that right. Let's see what else we got. Truly Laws said on an 8-hour layover, thanks for passing the time. I don't know if we're going to quite go 8 hours, but my guess is we're going to be pretty darn close to an hour on this one. All right. And then the next one that they cite is D. So we'll go to 1446D. Notice to adverse parties in state court. Promptly after filing such a notice of removal of a civil action, the defendant or defendants shall give written notice thereof to all adverse parties and shall file a copy of the notice with the clerk of such state court, which shall effect the removal of the state court and shall proceed no further unless and until the case is remanded. So that's another interesting part here, because this states something that's obvious. The federal judge can just say no and remand this case back down to state court. That's something that's very possible in this case. Now, I will tell you, my normal process here, if this was my case, right? If this was not a Karen Reed case, if this was my case and I filed this complaint, I would assume it's going to be removed to federal court. I would say that is the most common outcome here, is that this would be removed to federal court. But Karen Reed's case is different, right? It's one of one. There's almost nothing like it. I haven't really seen anything like it. So we're going to talk about what makes it different and what arguments can be made. Michelle said, I need Papa Tragos to weigh in on all this. Probably not quite his forte, although he is dealing with a civil case right now. They're trying to remove the federal court. I talked to Pete about it, who handles a lot of our cases that get removed to federal court as well. And I'll kind of share his thoughts throughout the video. I was going to have him on, but I think he's taken off here at 2:00. So didn't have time for that. But where was I going with this? Okay. So One of the major issues here, thank you, Tina K.S. Law Nerd, for gifting 10 Lawyer You Know memberships. One of the big issues here is this O'Keefe case. And if I'm Karen Reed's team and I don't want this case removed to federal court, excuse me, the Celsius is getting me today already. If I don't want this case removed to federal court, how can I get the court to exercise his discretion and kick it back down to state court? First off, just the craziness of Karen Reed's case, right? That's like one thing you can always try to use and say like, oh, this is, it's going to be a crazy case. But more importantly, I would again quote the O'Keefe's lawyer and talk about how they want to consolidate discovery. All these depots are going to be crossover depots. We don't want to depose all these witnesses 15 times. Like, we want to try to get the lawyers together, agree on one date, consolidate for purposes of discovery, quote unquote. Here's a problem with that. If we are going to consolidate for purposes of discovery, the O'Keefe case and this action, that creates a very, very big problem when it comes to federal court. So yes, both of these courts, the state and federal court that we're dealing with here, are both civil courts. Okay? We're not dealing one criminal, one civil here. But the federal rules of civil procedure can be very, very different than some state rules. Some, it can be very similar. But when you're in federal court, usually it feels like a fast track. You have to give initial disclosures up front. Some discovery can be more limited than what you can get in state court. No cameras in the courtroom, obviously. Some things can be subject to a federal protective order. There can be certain confidentiality agreements with some of the discovery. And that's not quite the same in state court. And a federal court judge is not going to appease a state court judge, is not going to accommodate a state court judge or any state court rulings. So things that happen in the federal court are how they're going to play ball. It's not going to be like what they're doing in the state court. So how are they going to deal with that? Very different rules, very different procedures, very different tracks, very different ways the courtroom is open versus closed. So I would make all of those arguments if I'm Karen Reed, that we're supposed to consolidate with this case for purpose of discovery. Everybody agrees with that. I would throw that in there if, in fact, they do agree. And we think it should be consolidated altogether. Even the House defendants put in their removal motion or notice that this is all inextricably intertwined. Same case and controversy, same date range, same people, same death, same criminal prosecution. It's all the same, Judge. And we think down the road, and even if I'm going to quote Mr. Diller again, I think it was Mr. Diller, it might have been the House defendants in their response motion, after discovery, even the defendants think there's a chance that this all gets joined together. So if we're going to join with another state action, why not just let the state court handle this 1983 action? They can do it. There's some other state causes of action that are very similar to that. I'd make that exact argument if I wanted this in state court versus federal court. Because usually as a plaintiff, I would prefer it in state court versus federal court because state court discovery is usually more broad. It's a little more loose in state court. The number one thing when it comes to trying a case is the interaction you get with a jury in a state court. I should say, in just most of the federal courts I've practiced in have been a lot more limited, especially in civil cases. Criminal cases, you can usually push because those pesky constitutional rights. You can usually push for more interaction with the jury. But state court cases, we submit questions. The judge is like, no. I go and ask again, Judge, can you please ask this question? No. Those are all questions I dig into on state court cases. By the way, plug for my podcast coming on Monday. It was one of my favorite interviews ever. I don't think I've ever learned more in a podcast. I don't know that we've ever learned more after a trial about what happened before a trial. All the questions we had while watching the trial, the main lead trial counsel answers all of them, and with great depth and explanation. I loved it. Please subscribe, hit the reminder bell. Do not miss that. I think we're going to post some longer clips this weekend before we even release the podcast to let you wet your beak a little over this holiday weekend. I loved it. And I will continue to follow him. Why would this be moved to federal court, and who does it benefit, if anybody? So the reason it would be removed to federal court is because Karen Reed's team filed under a federal statute, Section 1983, right? We know that's a violation of your civil rights. It's a federal cause of action. It's a quote unquote federal question, which gives the federal court jurisdiction, and they may choose to remove it. They don't have to, but they may. Y'all see Buchanan shared the McAlbert fundraiser. Doesn't surprise me at all. Definitely seems like they're all working in concert. Okay. Next up, shouldn't they all have individual lawyers? Feels like they need to. I mean, would it be wise? Would it be wise for them to all have different lawyers? My answer would be yes. Do they have to? Not necessarily. If I was representing all of them, I will tell you what I would do. I would put together a very ironclad conflict waiver and make all of them sign this conflict waiver. I would not want a Daniel Rashbaum in the Adelson case to happen to me in live court with all these cameras on me like, oops, I never got that conflict waived in writing. Hey, Peter, regarding Slenderman case, didn't she admit guilt? Why was there still a trial and finding of not guilty and then not the sentencing phase? Okay, I'm going to answer this at the end as I'm sorry. My brain, I'm focused fully in on this topic. The federal judge applies state law for this case. So state law for the state causes of action, yes, but not the federal cause of action. So no, it could still be completely different. And how I've had them removed is they still put it on a federal track. And what rules of evidence they're going to use can depend on how the judge and the arguments end up coming down. Are we going to see Georgia Kaplan on your show? No, unfortunately not Georgia Kaplan. Would love to talk to her too, though. Happy holidays to you and your family, lawyer. Thank you so much. All right, let me see if there's anything else I wanted to talk about here. So another question a lot of people have is, who does it benefit in federal court? I would argue it benefits the defendants more than it does the plaintiff, which in this case would be the House defendants and cops, not Karen Reed. That's my guess. I mean, that's just it doesn't mean she's going to lose, right? It just, from my perspective, makes it a little bit harder. And obviously, in case anybody hasn't noticed yet, Karen Reed's team likes to use the cameras and the media and people being able to see what happens in the courtroom, the transparency there. They like that and they know how to deal with that. All right. Anything else on this? Happy Thanksgiving, lawyer, fam. Thankful for this community. Sending prayers to everyone involved in the Hong Kong fire tragedy. I have not seen this. So yes, absolutely. Sending prayers that I'll have to look afterwards. Max Sauce, thanks for letting us know. Thankful for you, Peter, your team, and this chat. You all add to my life. Have a blessed Thanksgiving with your family and friends. So you know what? It's a great way to put it. Kathleen, probably. I agree. You all add to my life as well. I love that. I love that saying. I might steal it. Okay. Let's get to part 2 here, which is going to have some crossover with part 1, as is the case always with these cases, right? There's always crossover. Let's talk Proctor. Let's talk Proctor, okay? Because, oh shoot, I just hit cancel. Because things are happening. And this is what we knew was coming. We knew the federal removal was coming, but we also knew discovery fights were coming. And whatever somebody can do to get information that's going to be helpful to you and bad for the other side, you do it. And when it comes to criminal prosecutions and criminal defense, sometimes you're limited on what you can get and what is relevant to the crime that the other side chooses to charge you with. You don't have control over that as the criminal defendant. You don't have control over a lot as a criminal defendant. You're responding, you're defending. So you can ask for documents. Sometimes you get them, sometimes you don't. Sometimes they're in the full control of law enforcement, state attorney's office, the feds. But when you get into civil court and you have just these civil lawyers, right, that just know civil law, a lot of times the breadth of what you can get can amaze you. And the lengths people will go to try and not answer your discovery just makes you want it more. And that's the scenario that seems like is playing out here for Michael Proctor. So we're going to read through this, and then we're going to talk about what this process looks like and how bad it can get for Michael Proctor, which then can seep into the other defendants associated with him. Memorandum of law in support of the motion to compel Michael Proctor to produce documents pursuant to subpoenas. Defendant Reed respectfully requests that the court compel former Trooper Proctor to produce documents due as long as 3 months ago. 3 months. And while you have Lally in the district attorney's office that doesn't follow up with cops, doesn't give them a timeline, doesn't track what they do turn over and what they don't, you better believe that's not how it's going to be here. If he doesn't turn something over when he's supposed to, he's going to hear about it. And not just him, but the court. And this is another thing, just strategically speaking in good lawyering, you have to let the court know every time something like this happens. Because if you let it go for 6 months and then you start complaining about it, the judge is like, why didn't you let me know? But if this is the third time that he has refused to turn over discovery or not turned it over properly or kicked the can down the road or made excuses that we are going to see here, you let the court know every time, because when it comes to the third time, the fourth time, and the fifth time, now there's going to be problems. Now there's going to be sanctions. Now there's going to be repercussions. Maybe not on the first time, maybe not on the second time, right? Especially in civil court. Now you go to federal court, good luck. Careful what you wish for. Kind of like Koberger and his team. You wanted a different judge. You wanted a different court. You got it. How did that go for you? So from my perspective, this is just the beginning. We're just scratching the surface of how bad this is going to be for Proctor eventually. So 3 months ago, they asked for this. Reed served a subpoena on Proctor in hand in July of 25. Reed also served a second subpoena seeking a discrete set of documents in October of 25. Proctor acknowledged receiving both subpoenas and requested repeated extensions to respond. However, to date, Proctor has failed to meet all new agreed to deadlines and has not substantively responded to either subpoena or produced any documents. The court should compel him to do so. By the way, it's important that we realize what case this is in, because this is considered a non-party subpoena. What does that mean? All of the people listed here are parties. C.F. McCarthy's, Karen Reed, the O'Keefes. This is that case. This is the wrongful death case filed by the O'Keefes. So Karen Reed and her team are filing third-party or non-party subpoenas on people that are not parties, that are just witnesses in this case. Now, when discovery, and I say when, discovery is served on Proctor in the other case, where he's a defendant, it's an even bigger deal. And now this is party. This is going to be requests for productions, interrogatories. You can get even more from parties than you can from third parties. But I think Proctor knows they're going to get this information one way or the other, but this is a case in which he's a third party. How do depots work? All the lawyers there. What if one lawyer is not supposed to learn something? Well, that's the interesting thing about whether or not we consolidate them or not. If I'm a lawyer in this case representing anybody, I can argue I need to be there. It's relevant for me to be there. They could have information that could lead to discoverable information for my client's cause of action, either for or against them, especially when we're going to have counterclaims and all this other garbage. So yes, depots, every lawyer that wants to be there should be able to be there. Now, sometimes if the House defendants want to say, you know, we give this person as tribute and we're going to just send one lawyer there, they can do that. And then they can share notes with other lawyers. Like I said, we have a case right now with like 40 different plaintiffs, and we're kind of voting on, you know, who the 3 firms may be that do all the depositions. So we don't have to have 40 lawyers there. So you can do things like that. But generally speaking, if they all want to be there, and it seems like they all want to be there on the defense side, then you've got to clear it with all these offices, which again, makes it difficult sometimes to clear it with all the parties. Plaintiffs allege that Reed backed her car into John O'Keefe on January 29, 22, and caused his death. They also allege that Reed created a false narrative that someone else killed Mr. O'Keefe. And that's going to be a fact that I'm going to continue to point out if I'm Reed's defense team, because this false narrative allegation in the complaint is exactly why all of this needs to be consolidated. That's what I would argue if I wanted it consolidated. So you put this in your complaint, I'm going to continue to say it. That's what makes all of this the same case and controversy and stemming from the same facts and inextricably intertwined. No. My firm doesn't have more than 40 lawyers. A case that I am on has more than 40 injured parties that all have their own different lawyers. It was that big. I think it's already shrunk now, and it'll continue to shrink as people settle out, things like that. and that the police investigation into his death was corrupt, biased, and designed to deflect attention away from law enforcement officers and their families who were inside the house of 34 Fairview in Canton. Okay, again, all of this is exactly what their complaint is about. Why are we not consolidating this judge? Again, I think it's a pretty good argument. Plaintiff's claim Reed's assertion of this false narrative supports their negligent/reckless infliction of emotional distress claims. That's what I've been saying since I read the complaint. You're opening the door to a lot of these arguments, and they're now putting this in. I mean, they're putting this in something that's a motion to compel, starting to drop the breadcrumbs, starting to educate the judge, starting to let the judge understand this is where we're going, judge, and how we're going to get there. Music to my soul said, happy Thanksgiving, Peter. I'm excited to follow these civil cases with you. This is where your expertise should shine as just a civil lawyer. Yup. Can reporters be in federal court? Usually, yes. And sometimes they'll let like sketch artists, but it's not quite the same. But yes. Rebecca, thank you so much for the super sticker and congratulations to the Cowboys. Huge win. Huge, huge win. Huge, huge. Okay. In an effort to defend against plaintiff's claims by, in part, proving that this narrative is actually true, on July 23rd, 25, Reed served the first subpoena on Proctor by hand. So they're like, hey, you want to know how we're going to prove our case, Judge? Former Trooper Michael Proctor. That's how we feel like we're going to be able to prove this case. Proctor led the investigation into Mr. O'Keefe's death, which led to Reed's arrest and prosecution. He is central to the narrative on which the plaintiffs rely. The first subpoena requires Proctor to appear for deposition and seeks various categories of documents, including all documents and communications concerning Reed, Mr. O'Keefe, and the investigation into Mr. O'Keefe's death. Other potential witnesses and suspects, and other relevant topics. The first subpoena required Proctor to produce these documents by August 5th of 2025. August 5th. So we are now August to September 5th to October 5th to November 5th. We're 3 months and 20 days late. Not from when they started to be, not from when they served them, or from when they were due. On July 28th, here's where it gets interesting. Attorney Daniel Moynihan, I'll call him Moynihan, Proctor's counsel in his administrative appeal of his termination from the Massachusetts State Police contacted Reed's counsel, stated that he was confirming that his office would represent Proctor in connection with this case, and asked Reed's counsel to continue the deposition and wait a week before settling on a new date for the production of these documents. Reed's counsel agreed. Look at how nice we are, Judge. Look at how accommodating we are. We're trying to make this easy. We're not trying to be jerks, which I agree to that as well. You want to show the court how accommodating you're being. Because when the other party continues to kick the can down the road and have dilatory tactics trying to delay these cases, it looks good for you, bad for them. Reed's counsel, but Attorney Moynihan did not follow up and did not respond to further emails from Reed's counsel on August 27th or September 11th. Again, they're like, every couple weeks we're emailing him, Judge, and we can't get a hold of him. On September 15th, Reed's counsel sent a letter to Attorney Moynihan's office demanding a response. The next day, another attorney from Moynihan's office, Mark Russell, responded to Reed's counsel. Attorney Russell indicated that his firm had not been retained to represent Proctor in connection with this case and did not propose any new deadline for Proctor's response to the subpoena. Now, what a courtesy would have been is to respond to them the first time, be like, hey, we actually don't represent him for that. Also not that big of a deal if Proctor's like, yeah, I'll keep paying you hourly, just keep representing me for whatever pops up, whether it's the administrative case or, whether it's Reed's case, whatever, miscommunication, maybe that's why you always want to get things. But regardless, I don't think there's any foul play on the attorney's part, but he's like, no, we actually don't represent Proctor for this, so we can't give you a date for Proctor because we don't represent him. Reed's counsel followed up multiple times to clarify if attorneys Moynihan and Russell's firm was authorized to speak on Proctor's behalf in connection with the subpoena. Ultimately, Attorney Moynihan stated the firm was not and claimed that he was only trying to facilitate a response. If I'm the opposing lawyer, I don't like that answer. It's like, you don't represent him. I need to talk to Proctor directly, or I need to file this motion to compel because he's not doing what he needs to do. Reed's counsel explained that he needed to confer with counsel who actually represents Proctor in connection with the first subpoena to see if the parties could agree to a new production deadline and avoid this motion practice that they're doing right here. Also, lawyers are not supposed to reach out to non-parties or parties or clients of other lawyers. When you know they have representation, you should speak to their lawyer. That's the appropriate thing to do. But you can't hide behind that if you're a guy like Proctor, saying, oh yeah, I have this lawyer. And the lawyer's like, I don't represent him. So it's like, can I talk to Proctor? Can I not? At some point, you got to be able to answer this with or without a lawyer. They don't even have to do this, frankly. They could have filed this motion to compel. No new counsel appeared, and Proctor did not produce any documents or written response to the first subpoena. On October 22nd, 2025, Reed served Proctor with the second subpoena, which relates to only documents concerning certain disclosures made to Attorney Moynihan the previous week by the Norfolk County District Attorney's Office and Proctor's decision to abruptly withdraw his administrative appeal as a result of these revelations. So they're like, was that timing? Was there a reason for that? The second subpoena was left at Proctor's last and usual address. After receiving a second subpoena, Proctor called Reed's counsel directly on October 24th and left a message. This is usually an indication, and this has happened to me before as well. This is usually an indication that he is not represented by counsel, because now he's calling you on his own. They spoke on October 27th. During that call, Proctor confirmed that he was not presently represented by counsel. So October 27th, we know Proctor is not represented by counsel yet. In the motion we just read, or the notice of removal that we just read, which I think was on November 25th, yesterday, he's got counsel that's talking to them. Why isn't his lawyer talking to Reed's team? And again, there's nothing I like better than citing to opposing counsel's motions or notices that they put in the court filing. Very clear, Proctor has counsel, and he's talking to them. If not, then they don't have this consent that they act like they have. So only one of two things can be true, and that's problematic. Reed's counsel explained that it had been months since Proctor had received the subpoena and that Reed would move to compel production if Proctor did not agree to an acceptable date by which he would produce documents. Proctor asked Reed's counsel not to serve such a motion that week to allow Proctor to engage new counsel. Reed's counsel agreed. Look at how nice we are, Judge. We agreed. We accommodated. We're trying to do the right thing. And Proctor said new counsel would reach out by October 31st. No new counsel appeared for Proctor by that date. Indeed, as the date of this motion, no counsel has appeared for Proctor, which is funny because this was on November 7th. Now we're getting even closer to the date of that notice. Instead, Proctor called Reed's counsel again on October 31st and said that Reed's motion to add parties, which had been served in the interim, had caused the attorney he planned to hire to refuse the engagement. Uh-oh. Are there any lawyers in Massachusetts that don't know who Michael Proctor is? He's like, I got this lawyer. I'm all set up. Here's the lawyer I want to hire. And then when you guys had to go and move to consolidate all this and say you're going to sue me now, in addition to me just being a third-party witness, no, I don't want that. Could be nefarious, could be really bad for him, could be really difficult for him to get a lawyer, or it could just be a lawyer saying, hey, I thought I was representing a witness. That's the fee I quoted. Now that you're going to be a defendant, the fee is going to be a lot higher. And Proctor's like, well, I don't want to pay that fee, or I can't pay that fee, or whatever. It could just be as simple as that. Or it could be, I don't want to get into this mess. I would be shocked if Proctor can't find a lawyer, right? Like lawyers, we are meant for things like this. You hear about the lawyers that represent the worst of the worst. People that commit horrible acts of terrorism or crime or things to children and women, and they still find lawyers, right? Lawyers represent and fight for the rights of people, the constitutional rights of people. And they fight for a fair justice system. They don't always like their clients. They don't always agree with their clients. So I would be absolutely shocked if Proctor can't find a lawyer. RJ Medic, thanks for gifting 5 Lawyer You Know memberships. All right, let's jump to the analysis here. The court should compel Proctor to produce all documents and information in his possession, custody, or control that are responsive to the subpoenas. The subpoenas seek potential evidence that would be highly relevant to the truth of the alleged false narrative. I missed something. Proctor asked for even more time. Reed's counsel explained he could not agree to further delays where the documents in question had been due 3 months earlier. Proctor has not objected to either of the subpoenas. Okay. Now, the court should compel Proctor to produce the documents. The subpoenas seek potential evidence that would be highly relevant to the truth of the alleged false narrative plaintiffs rely on for their emotional distress claims. Again, I told you those emotional distress claims open Proctora's and Pandora's box as far as it goes with discovery. Things we've never seen before are going to come out in this discovery. Again, Proctor led the investigation, was a primary focus. Specifically, Reed has alleged that Proctor deliberately ignored, manipulated, or falsified evidence to direct the investigation away from other potential suspects and towards Reed. It is vital to her defense that she be permitted to, among other things, prove that such allegations were true when she made them, and Proctor's documents are directly relevant to that point. Therefore, they're well within the scope of discovery. There is no way she loses this. No way a judge is like, yeah, I don't think what Proctor has to say is relevant because of those emotional distress claims. They opened it, they busted it wide open, as the kids say. When you make that allegation, that's a false narrative, and she was lying and doing all, it's like, oh no, I wasn't, and I'll prove it to you. But I need discovery from Proctor. Whether or not he's a party, whether or not we join these cases, it is absolutely relevant to Karen Reed's defense because of the way the O'Keefes pled this complaint. If it was just a wrongful death, I still think they would get a lot. But the whole thing with Turtle Boy and false narrative and publicizing it opened the floodgates. Although Reed cooperated with many of Proctor's requests for extensions to avoid the need for motion practice, like, look at how nice we were, Judge. It has been 3 months since the vast majority of the documents were due, and Proctor has not committed to any deadline for production and is not, to Reed's knowledge, currently represented by counsel with whom Reed's counsel can confer. Therefore, the court should order Proctor to comply with his obligations and produce documents. Very, very interesting. Thank you, Quinley, for gifting 5 Lawyer You Know memberships. Okay, so let's now talk about some of the things they're asking for. Documents requested. All documents, video or audio recordings, and communications included but not limited to emails, text messages, and other forms of instant messaging to, from, or concerning Karen Reed or any of her family members, heirs, assigns, employees, contractors, agents, attorneys, or other representatives. Do you think he has some thoughts or text messages about Alan Jackson or David Yannetti or Alessi? This is all of everything. We know his personal email is involved. We know they've already downloaded his phone. They want everything. So I think this is much more broad than whatever he turned over in the criminal case. But I have a question for the chat. Do you guys think that Michael Proctor, former trooper Michael Proctor, is going to hand over all of this information? Here's all the videos, text messages. Do you think he's going to hand it over? Even if he says, I'm responding to this, here are the documents responding to request for production number 1. So I think everybody in the chat saying no. I tend to agree. And I'm not, calling Proctor out any more than anybody else already has here. A lot of defendants and a lot of witnesses try not to. They try not to turn over everything. And sometimes we never know. Is this really everything? Are they hiding something? And the answer might be, you'll never know. How could you ever know? You're not just able to download witnesses' phones and look through all their emails and text messages. So there is somewhat of an honor system to this. But here's the problem for Michael Proctor. If there is one email or one text message or Facebook message or Instagram message that he does not turn over willingly in discovery that I have from his cell phone download, because let's get one thing straight. It's very clear. Michael Proctor does not know what's in his cell phone download. His lawyer was like, you're not going to find anything. He got a new cell phone, last year. They're like, how about 10 years of information from his cell phone? So he doesn't know what's on his cell phone. So if I find one thing in the discovery he willingly turns over in either of these cases as a witness or as a defendant that is missing, that I got from his phone, I'm hammering him in front of this judge. Judge, this is a violation. This should be sanctioned. There should be an adverse inference or instruction given to the jury that he's hiding evidence. We demand he turn everything over. We had his phone because of this other situation going on. Maybe now, Judge, the only way to cure this, let us download his entire email. Give us everything in his email. Put it to a taint team, whatever. but I am lighting him up every single time I can prove that he withheld something from discovery. And at some point, the judge is going to be like, this is intentional. You can no longer feign ignorance here. You can't possibly say, oh, oops, I didn't mean to send this very relevant text message that was about Karen Reed or the O'Keefes, which, by the way, we're going to get to some more. I'll read some more things that they want, and you'll see how this is growing into things we've never seen. All documents, video, or audio recordings and communications. So it's like everything, all everything concerning the Lexus. All everything referring to the death of John O'Keefe. All everything concerning John O'Keefe, Paul O'Keefe, Margaret O'Keefe. Now, will the judge say, oh, no. Those are the victim's family in a criminal case. We can't possibly allow you to get that information? No. They are now civil plaintiffs. They have put that at issue. They have put those conversations at issue. Now, there may be things that are inadmissible that don't come in at trial, but are they relevant for discovery? They reasonably likely to lead to potentially discoverable material? I think the answer to that's going to be yes for the most part. Resisting arrest. Thanks for gifting 1 membership. All documents, video, all everything concerning Brian Albert, Nicole Albert, Chris Albert, Julie Albert, Colin Albert, Brian Higgins, Jennifer McCabe, Matthew McCabe, Allison McCabe, Carrie Roberts, or any other individual present at 34 Fairview. And they have to throw that qualifier in because for a long time, they didn't even know who was there. So anybody else that was there. And just so you know, there is some leeway, and courts usually give grace if it's like, oh, I forgot this person was there. Okay, fine. But if we know somebody's there, like, do you think there's any conversations about should we put Colin Albert's name in or not? Do we want to let him know Colin Albert was there? All of those conversations with anybody must be turned over now as part of discovery. This is what I was talking about when I said, you guys just can't believe the information you can get in civil cases. And what will be interesting is if there's any restrictions in federal court, there's still witnesses in the state court case. Very interesting. Priya said, would you take it? No, I would have to pass. Probably am conflicted off this one. Tracy, thank you for gifting 5 Lawyer memberships. Okay. Forensic examination and copying all cellular or smartphones, computer tablets, smartwatches, GPS devices, nav systems, or other electronic devices that record their location or can facilitate communication of any kind, which you either personally or professionally at any time used from January 21st through the present. That might be a little broad because you can object to these individually, like too broad, too vague, not reasonably believed to lead to discoverable material. All documents, video, or audio recording, text messages concerning any member of the Canton Police Department. Again, from January 28th to the present. I think there probably is a good argument that that's a little too overly broad. But they're going to be able to get some of it, right? They may have to limit it to the time period, but they're definitely going to get some of it. All documents, video, or audio recordings. Okay, all everything. Concerning 34 Fairview, all everything. Concerning any dog. Was he involved in finding Chloe and testing Chloe and, getting her teeth formed or whatever? It's like, was he involved in any of that? Because who probably was is Tully. And Tully is going to be a witness and going to get a very similar subpoena. So is Buchanan. And they're also going to be defendants in the other case. All documents, video, or audio recordings and communication included but not limited to emails, text messages, and other forms of instant messages concerning any investigation by any federal agency, department, board, administration, office, or agent relating in any way to the death of John O'Keefe. Any gifts, anything, all of everything concerning any gifts from Albert, McCabe, Roberts, Higgins. Anything from Yuri Buchanan. Everything from appealing your conduct as a trooper, which I think is interesting. Maybe they'll say that's not relevant. I don't know. I think it is. All records of any iCloud or other backup data, including any documents, communications, messages, or other data, including metadata that were sent, received, created, edited, stored, copied, altered, or accessed between January 28, 22. Again, to me, might be a little overly broad. Is the second subpoena here? Okay, here we go. All communications with or concerning the Norfolk DA's office, any employee, agent, attorney, or other representative of that office from July 1st, 2025 to the present. So this is, again, focusing on his fighting getting terminated. All documents received from Norfolk DA's office or any employee, agent, attorney, or other representative from July 1st, 25 to the present. And was he talking with them, trying to get their help for what's going on with this subpoena? Because I think they said July is when they sent that first subpoena. All non-privileged documents communicating relating to the recent disclosure Brian Moynihan referenced in media reports about why you withdrew your appeal of your termination from the Massachusetts State Police. One such media report may be found for your reference here. So here's the problem when lawyers go and they speak out. You are waiving, if you talk about anything privileged, you are waiving that your client's attorney-client privilege about the topics and conversations about which you're telling a third party or to the news media, to YouTube, whatever it may be. So if Moynihan goes on and talks about why you dropped your appeal, if you have any text messages or emails about that same topic saying, I'm dropping my appeal for X, Y, and Z, which is the same reasons Moynihan said, did you waive privilege? Is that something that Karen Reed's team is going to get their hands on? Maybe. Probably future arguments there. So I do think a lot of these documents are going to be objected to. A lot of these requests for production are going to be objected to, but you have to actually object. Usually you need a lawyer to do that. People can do it themselves, but you have to object and you have to say why you're objecting. So once you say why you're objecting, the other side can respond and say, no, that's not good enough. That's not a good enough reason. That's not real. It is reasonable to believe this is going to lead to discoverable material. And this is why. This is how it's relevant, Judge. This is why I need it. Can they prove Cora is Chloe and not a replacement dog? I don't know. Not a dog expert. You'd probably need an expert for that, I would assume. Esquire Boone can represent Proctor. She's got the time and experience. She's probably the right price. Why is the date for the O'Keefe family different than the date of death? I don't know. They probably pick days before and after. Sometimes you don't pick the exact date. Given what we've heard so far, what's the single biggest unintended risk you see with making this Proctora's box move? For the defense, nothing. Anything that was good for the other side, Proctor was already going to give it to them and cooperate with them. And if you mean from the O'Keefe side, what was the biggest unintended risk? Discovery is going to be huge. Huge. You've opened up so much more for discovery. But maybe it won't matter. If Karen Reed was going to sue him anyways, they were going to get all Proctor's discovery anyway. I'm curious, when you are ordered to surrender your phone so they can look at everything you have, whose job is it to sift through all of your stuff to determine what is relevant and not relevant? So usually there's a taint team or somebody set up that knows what they're doing that's not going to use any of the other stuff against you, or, embarrass you or leak it or things like that. There's somebody specific put that it's their role to do that. Sometimes it's a law enforcement, sometimes it's a state attorney employee. I missed the beginning. Why was the case removed federal court? So it hasn't been removed yet. There was a notice to try to remove it because this is about a federal question, which is the 1983 action, a federal cause of action. Nurse of interest, PETA. Be honest. Are you more excited about the Karen Reed case or the FSU versus Gators game? Karen Reed case. I don't know if I'm not excited about the FSU UF game. That can either be a really great day or a very miserable day. That makes me not happy. And you guys know I'll be sad on Saturday. I just realized I'll be sad on Saturday if we lose. As bad as our season is, if we can just beat the Gators, it's like, okay, not bad. Ashley, how do you decide what order of depots you should do? So there's a combination of ways. In a perfect world, I would like to talk to somebody that was there from beginning to end, that has the most conversation, that can give me the most names of people I'm going to have to depose in the future. I don't really want to go backwards where it's like, I'm almost done and this person gave me 10 new names I have to depose, right? Sometimes that happens. It is what it is. But a lot of times those people can talk about the policies, procedures, documents that may exist where I can, because this subpoena or request for production, you'll file them a bunch of times throughout the case. After every depot, we're usually filing more requests for production because this witness told us about documents that may exist. We want to know if they exist. And if they don't, what are you talking about, bro? And if they do exist, do they say what bro said they said? I sound like my kids calling everybody bro. But yeah, so In a perfect world, I want to go from who knows the most to who knows the least, like who has the broadest knowledge to who has knowledge of a specific fact. That's how I'd like to do it. And I like to do parties early on because I want to hear what the parties say. And then is that going to match up with what the rest of discovery says? Are the parties on the same page as the witnesses? Peter has a Bob Sura jersey 100%. I would. Charlie Ward. There's lots of good FSU basketball players, okay? Not just one. All right. Let me jump to Azam's questions here. Okay, Slenderman case, did she admit guilt? Why was there still a trial? Oh, because they did the trial to determine whether or not she was insane. So if she was not guilty by reason of insanity, she goes to the mental health institution instead of the jail. Also, from the wolf analogy, wasn't the Slender Man here the same as the wolf in the analogy? She was aware that she was killing a human being. I don't fully remember what the wolf analogy is, but this is the question you have here. I don't know all the evidence that they presented. So there's a lot more than just she thought she was doing this for the Slender Man. But exactly the question you have here, is this the same? Is this different? Is she legally insane or is she not? That's why they had to go to the jury. So you kind of answered your own question, Azam. You're getting good. You know where it's going. Rivalry games are different. Go Noles. Yes, I couldn't agree more. Go Noles. By the way, I gave away 2 courtside basketball tickets with lounge access to all you can eat and drink on our Twitter this yesterday, actually. We're going to do it on Instagram as well. So if any of you guys do not follow me on Instagram at Tragos Law, go give it a follow. You could win some courtside seats. We're going to do more giveaways like that for some fun stuff we have coming up over the next month. Yeah, I see more people talking about the fund for the McCabe's and Alberts, etc. No, not me. Won't be me. So if you see it again in the future, I don't care if it says Peter Tragos, Peter L. Tragos, Tragos Law, lawyer, ain't me, will never be me. Don't worry about it. Yes, it was awesome. It was so fun to do. I love doing it. I love talking to the family we gave them to because it's 2 tickets. So awesome. So awesome. Yeah, if I had some Massachusetts courtside seats, I bet that'd be pretty big. Maybe we will. You have to follow me on Instagram to find out. And hit that like button if you guys haven't already. I appreciate you so much coming and hanging out with me on Thanksgiving Eve. I'm so excited. I love the holidays. We play Thanksgiving football. It's something my kids and my nieces and nephews and some of my friends' kids get so excited about. We do it in my front yard. It's like a dream. It's like from a movie, I swear. I absolutely love it. And guess what? Daddy's shoulder's feeling good. And I play quarterback, man. I'm QB1 over here. So we got to get it warmed up. We're ready to rock and roll. We will win Thanksgiving football. We've won the last couple of years. You guys are the best. I appreciate it so much. Yeah. If it says Peter Gator fan Tragos, it isn't you. Yeah, that's for dang sure, Team Brittany. All right. Love you guys. You're the best. I hope everybody has an amazing Thanksgiving. We'll still be posting and, I'll be checking out the comments and things you guys are making and say so we can stay connected over the holiday weekend. I love seeing what all you are thankful for and sharing what we're thankful for, which includes you because you add to my life, as Kathleen said earlier. Okay. That's all I got. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.